Good afternoon, everybody. Thank you for joining. As you know, this year is quite different from all the previous years from the point of view of the Law Firm Management Conference. And obviously, we are all suffering because of the COVID and because of the inability to communicate properly and to be in touch properly. And unfortunately, I have to inform that this year the IBA decided that they will cancel on the offline conferences till the end of the year. So from the point of view of the Law Firm Management Conference that was initially scheduled for December 4, we have to apologize maybe and, unfortunately inform you that the real conference, the person-to-person conference, quite likely would be canceled. We will try to do something, to keep you interested in our event and, to keep you informed about what's going on in the world. But otherwise, it is quite unlikely that we'll be able to handle this conference, at least, as an IBA conference this year. It will be definitely not canceled in general, and it will be definitely transferred to the next year, but the date for the next year conference is a bit more complicated to identify. So what we decided to do is to keep up, with our connections and to keep up with you guys during this period of time, and to have a series of online discussions that were initially focused on the preparation and kind of, discussion anticipation of the discussion at the conference. However, we believe that these discussions are of value to all of us, even prior to the conference, because, time is changing our operational models, and time is changing our communications with the clients. Our time is changing our communications between ourselves. And I think it's extremely important that people are able to share their views and ideas. That's why we decided not to call these events as a webinars when, we standardly have panels and, people who are talking, but we would like to make them online discussions when each of you will be able kind of to share your views, maybe to ask questions, maybe to kind of, propose some other interesting ideas that may be of value for the whole legal profession, at least the regional part of the legal profession. This particular event would be dedicated to probably the most important parts of the professional life, communication with our clients. And we have absolutely brilliant panel of people who would like to share their views. I will give the privilege to introduce the panel to my colleagues, but I would be happy to propose to introduce to you Norm Clark, who is one of the probably most well-known in the international community legal community advisor with regards to the issues of the legal profession, professional life, professional development, law firm developments. Norm is located in the United States in Florida, so if you have any questions about Florida, how life is going on, in addition to schools, that's what you've probably heard we discussed, Norm would be happy to answer. And we have also Sergey Lepitan, who is General Counsel of Ran Baxi, one of the most well-known speakers of the Russian legal profession, I believe. And it's already his second time when he's moderating, I think Sergey's second, right? Time when you're actually speaking to the Law Firm Management Conference. And I think that's because Sergey was in different positions, this gives him quite an interesting possibility, not just to talk as the general counsel, but also as the lawyer who is working in the law firm. Otherwise, guys, I would like to mention that we have, this is our second online discussion. We plan to have another 7. And I would be happy to invite all of you to join the further online discussions and to participate and to give your ideas. And as I've said before, one of the main ideas of this online discussions was not just, to talk, but to hear you, and also to give you the possibility in future, those who would be mostly interesting to our discussions, to join the conference as panelists and speakers, and also to be able to kind of, have more active participation in the organization of the event itself. But now that's kind of, I would like once more to thank you for joining, and I would like to give the words to Sergey and to Norm.
Thank you, Vlad. Good afternoon, everybody. As far as any questions about Florida, all I can say is yes, Florida is as crazy as you have heard. But going to the topic today, I'm Norman Clark, as Vlad mentioned, and I've been affiliated and associated with the annual Law Firm Management Conference in Moscow for many years now. And it's been interesting to see how some of the issues remain the same, but every year they seem to take on a new character. And this year, one of the key issues that our firm, Walker Clark, is hearing from our clients is the changing nature of client relationships. What goes into a good client relationship? A lot of our clients and professional friends describe the relationship between the client and the law firm as a professional friendship. And as we know from our daily lives, friendship isn't a big thing, it's a million little things. So that's what we want to explore with you today. My contributions will be mostly from the law firm perspective, since my firm and I focus almost entirely on advice to law firms. And Sergey is going to present the in-house perspective, the client's perspective today with his comments and his contributions. So let me pass the ball to Sergey. Perhaps you could tell us a little bit about yourself and your perspective on this topic.
Thank you, Norman. Vlad have made already short introduction. I can add that within the last 20 years, I worked as a legal advisor or the head of the legal departments at the different Russian or foreign companies. Within the last 10 years, I work in the area of pharmaceutical and medical devices. And my present place of work is the Russian daughter company of the group of Sun Pharma. Sun Pharma, it's the largest Indian pharmaceutical company, and it's one of the largest worldwide companies, so-called generic companies. So these are just a few words about myself.
As Vlad, thank you, Sergey. As Vlad mentioned, one of our goals in this session is to collect information, to collect insights, opinions, and to have a discussion about some of these issues to help us focus the session that we will have at the conference, whether it's a live conference next year or a virtual conference sometime later this year, but to focus in on the issues that are really important and to understand what those issues are so that we can explore them further the next time we are all together. Now, in collecting this information, because of the significant number of people that are participating, there are really two ways that you can participate. One, if you wish to speak, ask a question, or make a comment, is to raise your hand. You will see that there is a little upraised hand icon on your screen. And doing that, we can connect you and we will be responding to the raised hands in the order that they appear. The other way, and perhaps one of the most important ways to participate in this conference, is through the chat. If you have any comments, any suggestions, any ideas that you wish to share with us, probably the best way to do that, in addition to raising your hand, is through the chat function. Just send us a text. This session is being recorded. All the chat will be recorded so that we'll have a record of everybody's contribution today. So with that, we'd like to turn to the first topic. Planning this session it occurred to us that there are really two perspectives on this issue of clients as friends. One is the relationship that clients have with their law firms. Somebody once said that the most important thing in defining what a law firm is who are that law firm's clients, because those relationships can become very special over the years. And we'd like you, as we discuss this topic, we'd like you to think about two aspects of this. Of course, you want the clients to come back to you if you're a law firm. And so what are some of the things that govern the decision-making process that a client has in selecting a law firm? These are the things that we'll be discussing in part one. The other aspect, and this is an aspect which is overlooked by many law firms, or in fact, in some cases, even unknown by many law firms, and that is the role of the client relationship as a marketing force for the firm. It's one thing if I have a law firm with a wonderful website and my clients like me and they keep coming back to me, but it is another thing, a much higher level of client engagement, if those clients start recommending me to other people in their industry sector or other people that they know in the community. So friendship really goes in these two directions. So let's begin with a consideration of some of the factors that are important to clients in the evaluation, selection, and retention of law firms. And Sergey, since you're a client, what are some of your thoughts on this?
You see, Norman, yes, I fully agree, and that's why we changed a little bit the name of the session. We make it a friendship. We call it friendship between law firms and clients. I must say that this name of the session, it was taken from Mark Twain. It's one of his sayings that friendship is not a big thing, it's a million things, little things. And first, we would like to show that, and I think that everybody will agree with us, that it's a kind of, this kind of relationship, like maybe many other relationships, is a kind of a two-way traffic. That's why we decided to divide our session in two parts. First, we see that in these kinds of relationships, there may be some clients' challenges. Do believe me, me as a in-house lawyer, we really face some challenges while selecting this or that law firm. At least luckily here in Russia, in comparison with the 90s, when there were very few law firms at the Russian market. But nowadays, there are hundreds of them. So sometimes it's really a big challenge to make a choice in favor of this or that company. That's why we decided to ask our speakers to answer on simple question. What are the major criteria they apply when they select this or that law firm? And there is still an issue when you make a selection between Russian firms and international law firms. Especially it is important for the international companies. That's why we concentrated or decided to concentrate on these particular issues in the, let's say, first part of our session.
Well, let me throw the question out then, the first question, because I noticed that we have a number of people from the Russian Federation and a number of lawyers from outside the Russian Federation. Let's start with this first question. It's a very interesting one. It's one that in our firm we get asked quite frequently, and that is, what determines whether an international client or a foreign law firm should refer work to a local Russian law firm or to an international law firm that might have an office in the Russian Federation? What are the factors that go into this decision-making process about whether to go with the big international firm or with a national firm? And we'll throw this open for any comments from anybody that's participating. Well, in classic law firm fashion, since nobody has answered yet, as the professor, let me pick a victim from the audience. One person who is a dear friend of mine who I know has worked on both sides of this question is Alexander Kuczynski. Alexander, what are your impressions?
Hello.
Hello.
Yes, I managed to. Thank you, Norman. Okay, so you really put some burden on my shoulders. Oh, okay. Well, the considerations of the clients could be so different, and there should be such peculiar settings of priorities in the selection process of the client. But generally speaking, I would rather, if I were the client, I would rather check first the speciality you really require. And in certain cases, because of the speciality, you would have to consider a limited number of law firms in particular that could be specifically Russian domestic law firms or international law firms, depending on what kind of question you have. But then there could be an issue of the confidence and trust. You could ask, well, you can ask yourself, anyway, so this consultant should be someone I could really trust. And in that case, again, it could be either domestic consultant or international consultant, depending on your previous experience in hiring the outside counsel. And well, even financial issues can be at stake. I can imagine a client thinking that, well, I probably cannot afford someone with more experience on the matter, but I would rather take the law firm with less experience, but the law firm that I can really afford, that can offer me some kind of competitive price. And then I would be looking for the good price quality ratio. And then again, I might consider hiring rather domestic law firms because of the price. So it could be different constellations, and depending on what you really want, what you really expect, what your previous experiences with outside counsels were. That would be my answer.
Well, you use the word trust. You used the word trust several times. How is trust built? How do you build trust in a relationship? Particularly if it was the first time that I, as a law firm, have done work for a client.
Yeah.
How do I build that trust so the client becomes a friend?
Well, I would rather build it as a building, floor by floor. So a kind of fundamental level would be based on the fact that I actually, what is behind my brand, what I can do. if the client knows what I can do, that's a kind of a ground floor of relations. Then I would go to the first floor and to make certain that the client and I both know that I can do something that the client wants. That's the next level, so to say. Then on the next level, I would rather try to make my client really believe that I can do it better than any other alternative instrument that the client can use to approach the matter. And that is a so-called competitive level. I have to be the best among others who can do this. But if I would be really interested in the long-term good relations with the clients, I would rather go to the penthouse of this building, and I would really try to find out, I really want to make certain that we have some kind of irrational sympathy with each other, with the client. So the client really strongly believes he is emotionally comfortable with me, and it is a mutual thing among us. So then that would be a building of the relations, 2 floors, penthouse and ground floor.
Let me throw this question out to everybody in the meeting, and to participate, if you want to, you can simply unmute your microphone and participate. Specifically with respect to the differences in the capabilities between Russian and international law firms, we have seen over the past 20 years, certainly, that a lot of the competitive gaps that might have once existed between the international law firms with offices in the Russian Federation and the local law firms, the national law firms, a lot of those competitive gaps have closed in terms of the capabilities, the expertise, the service delivery, and so forth. What, if any, particular advantages do local Russian law firms have representing foreign clients? What are your opinions on that? And just go ahead and, if you wish to say something, just unmute.
Well, this is still Alexander, if I'm not too annoying. And I believe I believe the area of specific expertise that is probably too narrow for the big thinking law firm. This is something that the Russian law firm can offer as a competitive advantage. You could have had some specific experience in a specific issue rather than a big law firms that would address this issue for the first time. That would be the most significant competitive advantage for the Russian law firms, for the domestic law firm.
And any other views on that from any of our other members of our meeting?
Maybe the price?
Well, yeah, let's talk about the price. What has been the experience of everybody with respect to price? My observations from outside the market have been that for quality legal work, actually two observations. For quality legal work, there really isn't that much a difference in price. And the other thing that I've noticed, and this is not based on research, but just talking to people and anecdotal evidence, is that there is nonetheless a perception in some countries that Russian law firms would naturally be less expensive than an international firm with an office in Moscow or St. Petersburg. And people tend to be a little bit surprised when they see the fees. Joel or Felicita, do you have any thoughts on that? I noticed that you're on mute.
Yeah, this is Joel. Just so people know, I'm with Kinstiller and I run our practices in Central Asia, so in Kazakhstan and Uzbekistan. It's a bit different only because the market here is obviously smaller. I think in Russia you have all the major international firms as well as, you know, a lot of good Russian law firms. But I think on the issue of price, I think what we see is a misperception on the part of people about price. First, if they assume you're expensive, they sort of think like you're just too expensive. We don't want to use you, particularly for certain kinds of work. And they don't necessarily, in some cases, they just don't come to you. But I think what they find is if they come to you and talk to you and give you a sense of what they need and what the pricing is, I mean, we're one of those firms that'll say, look, you know, we just can't do it at that price, okay? It just doesn't make sense for us. But we may do it for the relationship, or if it's a firm that a company, we have a relationship, we often will do it because of the relationship. And I have I don't want to take a lot of time, but I'll just give one short example. Recently, we won a project finance against 3 very local firms. And I managed to see the quotes that were provided by all the firms. And we were actually the third out of we were not, there were 2 firms more expensive than us, one less expensive than us. And people wouldn't have expected that because the other firms were purely local. But the reason our price was there was because we understood. I said, you know, here's the number, but I said, this is the market and this is what I'm going to have to bid if I want this. And I was willing to give a fairly aggressive competitive bid. So I don't think price should ever be a factor for somebody until you at least ask. And I'll just leave it there.
Well, let's talk about those factors. Felicita, I noticed that you have turned on your microphone. Do you have something to contribute? Gerhard?
Maybe I'll add some things on behalf of the clients. So you see, every time, of course, we should take into consideration the company's procedures. Sometimes the lawyer have to organize a kind of a tender, and it is just simply prescribed by internal regulations of the company. In some cases, I had such an experience, even law firm services, they have to pass through so-called purchase department. And of course, at least at those places where I worked before, I was totally against such procedures to be applied in the process of selection of the outside legal advisors. I told them that's that big difference between when selecting the seller of some office equipment and the legal advice. And to tell the truth, I had a success, and I found such an understanding. Because yes, the matter of price is very important in the process of selection of the outside legal advisors, but of course, you should take into consideration all other things like expertise, experience, and all other things. So that's why I fully agree with you that the matter of price is still very important. But again, judging by my own experience, especially in cases when the prices, suggested prices are relatively at the same level, of course, you should take into consideration, of course, the industry knowledge, the specialization. Sometimes I take into consideration the ratings, especially Pravarу rating. So that's why it's, and it's mentioned in the name of our session, you should take into consideration a million little things to make this choice.
If you allow me for kind of brief comments about this. Actually, it's quite interesting because at some moment of time, Sergey and myself were in the same kind of legal position as a general counsel, one of the major international companies, and not simultaneously, obviously, but still we have the same kind of experience dealing with the suppliers. But of course, I'm looking at the situation from a bit different view as of today. And I would say that especially in today's markets, the price is necessarily not a competitive advantage for the local firm. In many cases, we can see that major international law firms are able to allow even lower prices in some cases. And the reasons may be quite different. I'm not going to deal with this issue, but you will always find somebody on the market who will be cheaper. And that's one of the concerns, I believe, that we have to take into account when we're talking about operation as a law firm, as a business. Because at the end of the story, there are two ways to handle your finances. And one of them is cash in, cash out. And at the end of the story, that's the kind of the basic of any kind of successful business. If cash in is more than cash out, then you're kind of alive. If not, then you're kind of bankrupt. But the other story is that you need to understand the level of efficiency, and you need to understand how exactly the system works for you and for your firm. So, for example, you need to keep up the office, you need to pay salaries, and you need to understand how exactly it works. So there is some limitation to any flexibility you can offer. And even though local firms are making decisions locally, that is actually make these decisions sometimes more efficient, they're still not capable to finance themselves through the head offices. And there is no banking financing for the law firm operation. So technically, if you want to keep alive, you need to be profitable, full stop. So that's why actually sometimes the flexibility in price is not really the benefits of the local firm. It's actually a drawback of the local firm because we don't have any of these extra resources that we are able to use for the support of the local operations. On the other side, in my experience, so many things are connected with the professional level of lawyers. And international firms were always saying that, because we're international, we have such a big experience and we have such a big knowledge and, so many people who are able to work on different projects that we're able to share this worldwide, and it's completely true. However, today's world is offering these kind of possibilities even to sole practitioners in any particular country. So the world experience, the world knowledge is actually existing, and it's achievable even if you are operating, I don't know, somewhere in Chita on a small project, because you are able to handle to get this through a lot of sites, through a lot of international connections, through a lot of kind of different sources. So from my point of view, one of the major reasons for the international client to select the local firm is still personal knowledge. So you know the guy or you know the person, you can actually rely on the level of expertise. You can rely that the person will tell you the truth. And for example, one of the truth maybe that he doesn't or she doesn't know what exactly is this topic about, and they're not able to give you any proper advice on this. And then, of course, how exactly this individual reacts to the kind of system of communication. So chemistry, in a way, is an important part of the relations with the general counsel. I understand that takes the relations to a bit different person, to different level. But if, for example, you cannot really get in touch in a proper way with the local counsel will never recommend you to the international counsel. And then, of course, you will never be approved as a firm. And from that point of view, I think that personal relations and, legal services, personal services, are still extremely important from that point of view. And they transfer not only to the particular lawyer that you are talking to, but also to the group of the team, because you believe that the team has a culture, and this culture can be, transferred from one lawyer to another. And so if you believe that this particular lawyer in corporate matter would be doing good, but then, most likely that the same different lawyer in IP would be doing the same way with the same approach. So I think that, we cannot underestimate the system and the value of the personal trust that is existing between the lawyer and the client in any kind of connections, and especially in connections with the international clients as well.
So we've talked about establishing trust as a very important factor, particularly in economically uncertain times, such as many of us are experiencing. And we've talked about how pricing can fit into the equation somehow. And of course, circumstances change. Just to put one piece of information into the discussion from our firm's experiences, one of the things that our firm does is surveys of clients of law firms. We've been doing this now since 2002. We have a database of about 8,000 clients in it. These are law firm clients. And we ask the same question on these surveys. How important are each of 20 factors that we list in your decision to select a law firm, or in your decision to keep selecting that law firm? And one of them is price. And we ask the clients to evaluate whether a factor is decisive. If you don't give me what I want in this, I'm not going to hire you. Whether it's important but not decisive, whether it's of secondary importance or not important at all. And the interesting thing is that of these 20 factors, price has never come up as one of the top 3 considerations in the responses on these surveys. It is indeed important to most of the clients, but it's never the most important, even with clients whom you would expect would be focused entirely on price. So perhaps we could say the price might be the price of admission to the competition, but it doesn't appear to be a decisive factor unless you are really out of line. What are some more thoughts about this concept of price? Joel, do you have some perceptions on this? I know you mentioned it previously.
Yeah, I do. I think, you make a point that people say price isn't ultimately the most important. And I agree, it's probably not when they're selecting the firms they would go to. But I think the problem is we as practitioners are often faced with everything from state procurement to just competitive bidding for transactions, where effectively I think what's happened is they've gone out to certain firms not on the basis of price. They've decided which firms to put it out to. And then price does become the factor, sometimes the only factor. We see that with people like some of the big multilateral investment, in financial institutions and investment banks, where when you bid on something, they've gone to the firms they know can do the work, and it may be the only factor. So that's why it's, I agree with you. There are other factors. You have to have a reputation. You have to have all these other things that make them want to come to you. But at the end of the day, when you're actually pitching, price does sometimes become the factor. And that's where it's hard, because, we often we're sort of a hybrid, right? We're international firm. We're in 10 different jurisdictions, but we're local counsel in our markets. And we bid for a lot of matters where we're bidding to act as local counsel together with some other firm on a matter. And we'll often give them a call and then say to them, especially the ones we have a good relationship with, listen, this is our quote, but tell us if, I mean, don't be shy about coming back to us and saying it's not going to get the deal closed here. I'd rather they come back and say, you got to go lower for us to get this deal than simply say, throw away our quote and go to someone else. It doesn't work for us that way. So it's you know, it's the unfortunate way of business these days, and which is just a reality.
Joel, have you ever seen this situation where you've been asked to submit a proposal and you do so, but you have a feeling that your proposal is really going to be used as a tool to negotiate some other law firm down in price?
Absolutely. And you know, it depends. I mean, I hate being used as a stalking horse. If I'm pretty sure that's what's happening, I won't do it. I'll just say we're unable to quote, or we'll bid high and just leave it there. I mean, I don't want to be in a position where they know who they want to work with, and I'm used as a basis for them to get a lot less money. That just seems unfair, and I wouldn't want somebody to do that to me. If I think I have a chance, I'll be aggressive and I'll quote aggressively. So yeah, I mean, it's interesting that you say that, but it happens a lot.
Any other thoughts about this factor of price?
I can add maybe that, you know, while judging by my experience of organizing several tenders, this idea which maybe exists in the minds of some legal advisors that the lower price they suggest, the better they will look in front of the client. It's not. It's for me. It's a wrong idea, because first, to my mind, it's a kind of way to nowhere, because once, just judging by my experience, once one company won the tender due to their very low price, but it was even a big surprise for me, because it was a pretty big international law firm, and it was the first time I came across when they suggested such a low price. I was a little bit surprised, but just in a few weeks, it became a big surprise for the law firm itself, because they came to understanding that their price was very low, unreasonably low, because the case was really very big. So that's why every time when you suggest low price, you should make proper calculations at least. And the second thing, do believe me that it's not the key factor which will help you to hold your client. Because in any time when I see such improper, let's say, pricing, it's a big question for me, how it happens. It's strange why the company started to dampen, really. And of course, yes, maybe your low price may be attractive for the first time, but in any way, if you want to have good relationship and long relationships, a lot depends on the quality and the quality of the answer, of the time speed, and other things. So you see, yes, price may be attractive, but again, it's not the key factor.
Mm-hmm. Well, I think one thing we're all agreed on is the danger of participating in a price war. Just one anecdote from our experience. One of the markets in which our firm works very heavily advising law firms is in Colombia, in South America. When we started working there in the early 2000s, the major Colombian law firms were in a price war. And the problem with low price as a strategy is if someone charges 1 ruble less than you do, or €1 less, or $1 less, there goes your strategy. And these firms are having significant economic difficulties making a profit because to survive, they felt they had to always have the lowest price. And finally, they began to consider some of the factors that Vlad outlined previously and realized that this wasn't the way to gain business, at least not the lasting type of business that they wanted. And a lot of it comes down, I think, to also in this area of pricing perceptions. And, what am I getting for my price? One last anecdote from me. Our firm over the years has represented a Russian national firm, advised them in dealing with clients and developing business outside the Russian Federation, attracting new clients, particularly from East Asia, into their firm. And I recall a series of meetings that we had, because I was present, with law firms in one of the East Asian jurisdictions to see just how the relationships were going and what the clients expected in the work that they referred to the firm in Russia. And I was struck by how there was a perception among so many of these otherwise sophisticated, important law firms that Russian law firms were cheap, that they were a bargain. And they were very upset at the fees that the Russian firm was charging for work, even though those fees were only about 65 to 70% of what the Korean firm or the Asia or the Vietnamese firm or the Chinese firm would have charged for the same work. So much of it is perception and how to match that issue of perception. Any other comments or observations before we move to a couple of questions under part 2?
Well, if I may, Norm, I will be short. I promise. This is Alexander. Well, if you have some kind of procedure like procurement within the firm, it is supposed to be a quality of the qualified buyer of legal services. But the procurement procedure is not the only part of your qualifications you need to make a smart choice in selecting outside counsel. If the company applies some smart policies towards overall assessment of the quality of the inside legal counsel, then a cheaper procurement ceases to be the only criteria that is being used by the top management of the client, whether or not we do our legal work, necessary legal work, in the proper way. So if the chief counsel is being assessed on the basis whether or not he purchased the cheapest lawyers, then we can face the lack of qualifications within the company. So then the procurement of legal services is still not actually reached. You have to assess a work of chief legal by using the most sophisticated set of criteria for your evaluation. And then, indeed, price issue will not become one of the top threes. I guess, Norman, the 8,000 lawyers in your database represent usually the company with a very, very sophisticated experience of purchasing outside counsel. So they are really qualified buyers. That might not be the case for the companies in the younger markets.
Any other comments along these lines? Well, let's go to the second part. The second part that we have on the screen, relationship with clients. This is from the law firm perspective and some of the challenges that law firms have in dealing with the client relationship. And we have suggested 2 discussion points that have become particularly timely. Unrealistic deadlines, and the second one being the problem of collecting the fees. We've seen these particularly since the pandemic has become more prevalent, because for one thing, we have all started using virtual meetings. And one of the problems with the virtual meeting, it's a benefit and it's a problem, is that you know that any client anywhere in the world, any law firm anywhere in the world, is only one mouse click away, regardless of time zones, regardless of differences in distance and local activities. And some of our clients that are law firms have been telling us that clients seem to be expecting even more in terms of responsiveness than perhaps in the old days. The other thing that we have seen reported to us from some of our law firm clients has been problems with outstanding invoices. Because as one of my friends in Western Europe said, you know, at the law firm, we are at the end of the food chain. We don't get to eat until everybody else has eaten. And this has been causing some particular problems for some of those. And there are other problems as well. So the question I'd like to throw out would be these 2, but starting with the unsubstantiated deadlines, and we can talk about the invoices, as well as any other issues that seem to be particular challenges for law firms in managing this friendly relationship with the clients. Sergey, do you have any observations from the client perspective on this?
Yes, I can add here that we decided to add this part 2 because I think that it's very important for the law firm. Just first, it's a good opportunity to ask such direct question to the general counsels, and I must say that we make a preliminary selection of the speakers already. There will be 4 or 5 people. They will represent different areas of businesses like media, pharma, medical devices, social infrastructure. So that's why all of them, I know all of them because I made such a selection. I must assure you that they're very experienced legal advisors, and they have years of practice being of the heads of the legal department. So this is a good opportunity to ask them direct questions, like about the deadlines, maybe sometimes which they insist on, or about issues with invoices which you may have. That's why you are welcome to ask additional questions. So me and Norman, we expect that after this session discussion, additional questions from you will appear, and we'll organize so that we'll make a preliminary walk with our speakers and make a kind of distribution of these questions. So please, you are welcome to ask these additional questions.
Let's talk about the issue of unreasonable expectations or unsubstantiated deadlines. From the law firm perspective, how do we deal with that? What should the response be? And this is not the occasionally short deadline, but this is a client who always sets unreasonable, if not impossible, deadlines and says, well, you have the technology, you guys should be able to do this without any problem. How do you respond to that? Some people have called that a client from hell. How do you deal with that type of a problem?
Norman, this is Joel. I hate to be monopolizing, but I think it's a little bit like training a dog. You know,
It will stay
or a small child. You have to be clear early. If you see this, you have the client who's being difficult all the time. And we all know that there are some clients who are just impossible, right? First, you have to think, do you want them as a client? That's the first question. But assuming you do, you need to have that clearly communicated to them about what you can deliver. I mean, you just don't say, I can do it, I can do it. I mean, once or twice you get pushed, you might have somebody work overnight on something. But at a certain point, you just say, we're doing it now. We've been on a transaction. One of my associates has been writing me stuff like, at 10 o'clock at night, he'll send me a message saying they've sent this to me and asked me to respond tonight. I said, well, it's 10 o'clock at night. You got it. I said, quite honestly, this isn't the first time. I said, if they'd given you a heads up and said, we need this response tonight, that's okay. And then, you know, obviously we need to be available. But as they hadn't, I said, the easiest way to deal with that one is simply not respond. Wake up in the morning, send a message saying, I just saw your email. I'll do my best to respond to you today. I mean, I think you just need to sort of help train them because some people just, for them, everything's urgent, even though you know those are the same clients who you send them something and then they sit on it 2 weeks, right? So it's really important to be either very explicit about what you can do, or the other way is to just ignore the deadline if it's, you know, in the case where I've mentioned where it comes in late at night. I mean, people can't expect you to be looking at your email all the time. He happened to have been looking at his email when I came in, and then just respond the next day.
Other views? Well, we've talked about this concept of making the client a friend for life, and to use the dog analogy, a best friend for life, and how to go about doing that. I've observed that sometimes there is some tremendous marketing value in doing the impossible. Now, this is not the client that always sets the unreasonable deadline, but the client that is in a situation such as Joel described, the client who really does need it right away. And I'm thinking about one of our clients at the law firm in Texas that has a client in the aviation industry and became involved in advising that client on some matters with respect to the approval of a merger with another airline. And for a variety of reasons, this was something that this piece of work needed to be done right away. That firm brought in something on the order of 20 of their partners and approximately 60 associates and other staff on a Saturday and Sunday to turn this around and to produce the product that not only met the client's needs and expectations, but exceeded them. And the impact on that client relationship was phenomenal. That client has truly become a client for life of that law firm, and the client is very active in marketing and recommending the law firm to others, not necessarily who are competitors, but others in the same general aviation-related industry. So sometimes doing the impossible can result in a real long-term benefit that you might not otherwise have. Alexander, you've worked both sides of this relationship over the years. So what have you seen? What would you advise with respect to the dealing with the unreasonable client?
Well, I absolutely agree with the approach of Joel. It really, well, everything that has been said made a perfect sense to me. It works together very well. Basically, you can always exceed expectations of the client by doing impossible. But another way of surprisingly exceeding expectations of the clients can be to be a good advisor for the client. You can make your client better. Well, Joe, put it by saying, you can train the client, or even tame the client. But it is something that is expected from the advisor. The client should believe that you can always take the client's interest a little bit above your own interest. And you can exceed the expectation of the client by saying, look, I mean, you really asked us to deliver something by early morning, but you didn't really require that. You didn't really need that. And it would be better for our relations if you can always put on realistic deadlines and instead can always rely that we will do our best. By teaching the client of better way of dealing in situation could be another type of exceeding clients' expectations, and it works.
Let me tell a short story maybe on this. It's a kind of a joke or fairy tale. You know, one client came to the shoemaker with a piece of leather, and he asked him, please make a pair of shoes. The master said, okay, I'll make this pair of shoes. But the client was very greedy. He came to him the next day and asked him, please, if you can make 2 pairs of shoes from this piece of leather. He said, okay, I can make 2 pairs. So you understand, it continues until the client asked for 5 pairs of shoes to make from the same piece of leather. And finally, when he got these 5 pairs of shoes, of course, they didn't suit him. They were very small. So I think that this approach is not good in case when you have relationship with your clients. You should every time warn your client that, guys, it may damage the quality of the work. When the client insists on these or that unreasonable deadlines, of course.
You've probably heard about this famous proverb. It can be either cheap or fast or good quality. You have to pick 2 out of 3. So unfortunately,
yeah, but you understand every time the client should understand that he doesn't need the useless things. That's the issue. You should warn the client.
No, that's absolutely clear. And, you know, from a number of perspectives, I think it's a perception, industrial kind of industry standards that you have to do as good as you are able to do, as fast as you are able to do, and as reasonably priced as you are able to do. At the same time, I agree with Joel. I think it's probably partially connected with training, but it's very much connected with trust.
Yeah.
Because if you are kind of care, if you show that you care about the client, and if you see that the client doesn't care about you, that very much actually disassembles the trust, and the trust cannot go just one direction. And I completely agree. In many cases, we're receiving the request saying we have to do this now. Like, it was already, deadline was yesterday, and then for 2 weeks the client is sitting on the document and nothing happens. And in this kind of situation, you are kind of, asking yourself the question, why people are actually spending night dealing with this document. And then, I understand that the client is busy. I understand that the work was required to be done in a very fast manner. But you kind of, I think the trust and respect should be reciprocal. Because if you don't trust your lawyer, if you don't trust, your advisor, you shouldn't use this advisor. If you don't kind of respect your advisor, you shouldn't technically deal with this advisor. But if you do, then it has to be a kind of open way of communication, both sides. And as I've said, we all face the situation when it's supposed to be done now. And I think that as lawyers working in the professional world, I'm not talking about young generation, they think a bit differently sometimes, but I would say the standards of quality and the standard of approach in the industry is that if the clients ask this to be done now, then we have to sit and do it now. But in case the trust is kind of, not, the trust is not working just one side or one way. It should be both ways. That's at least my understanding.
That formula of you can have it fast, cheaper, or high quality. That formula is very interesting because number one, logically it makes sense. But number two, we have observed over the years that increasingly some clients are demanding all three. And the industrial metaphor that was mentioned previously seems to be something that's entering into client expectations. Now, there was a question in the chat about client surveys, and particularly the client survey that I referenced, that our firm has done. And one of the things that has happened over the years is that as clients have become more sophisticated and more knowledgeable, they are demanding more of their legal advisors. One of my friends once told me that client ignorance is no longer a profit center for law firms, that they are demanding more. And increasingly, they're demanding all three, which is where a lot of the challenge comes in. And this seems to be something also as we've observed over time, because we've been doing the survey now for 18 years. Over time, we have observed a tightening up and an elevation of client expectations. Now, one of the questions that Alexander asked about that was, were these just random clients or sophisticated clients or what? And he alluded to something that I'd like to reinforce, and that is that we have observed that the more sophisticated clients, the in-house counsel, we could also include partners at law firms that refer work to local counsel, that in that sector of the survey population, we have seen the greatest increase in this sophistication. And what was important in 2005 now is even more important in 2020. So I think one of the problems is we're always trying to hit a moving target when we're responding to client expectations. Well, what about the second question, though, that the client who does not pay the invoices? We have seen among some of the firms with which we've worked, some of the law firms, we have seen, not surprisingly, that the age of their accounts receivable has begun to increase, particularly dramatically in the second quarter of 2020. What are some of the approaches that can be taken? What are some of the issues, and what are some of the approaches that some of you actually are taking in dealing with the problem of collecting of the fees?
Yeah, this is Joel again. Sorry, but
No, not at all, Joel.
yeah, collecting. I mean, it's a very interesting phenomenon. First of all, let me just give a quick point, which is when COVID started, our firm took a very, let's say, pessimistic view, or let's say cautious view, more than pessimistic. Real concern, and one of the things that we were put under pressure to do was to try to collect bills. And normally we were pretty lax. I mean, I think, 30-day payment terms, we don't do much. Probably till 60 days out, we don't really ping the client. Our collections right now, I mean, are the number of old outstanding invoices has gone down dramatically because we ping our clients early and often. So we even though we send it in 30-day terms, 2 weeks out, we basically send them a reminder saying, when can we expect you to pay? I think it's a little bit like, your doctor sending you a bill, you get it 6 months later, or you get it, immediately after you've seen him. You'll pay it if you've seen him right away, but a few months later, it seems to be, I'll have to look at this. I don't remember what was it. I mean, I think you get a better response just by doing that. And I think people don't historically do that because there's a sense that you don't want to bother your clients. And that's bull. What we've heard anecdotally is that, I mean, and I think you said it as well, was that, we're sort of last ones to get paid. But what we've heard from general counsel is that basically the clients, the law firms that are the ones that are after them are the ones that get paid, the ones, that are bothering them. So that's the first thing. Now, if you're talking about really, really old bills or a client who just simply ignores you, I mean, there's a point. I mean, I chased some very well-known investment banks for 3 years to get paid on a deal where basically, the underlying, the party that we acted for the banks on a deal where the company that was ultimately being financed refused to pay. And they sort of were acting like, well, we didn't get paid. Why should we pay your bill? And I didn't really see it that way. And I chased for 3 years and constantly. I mean, it was, and it, ultimately agreed to some abort discounts and other things, but I did get paid and the amounts were not insignificant. So, that, I mean, I think you really do have to be persistent. But the truth is, if you get a client who just wants to ignore you and walk away, and we've had those, you have to first think, can I collect? I mean, is it something I could go to a court and collect? There are some cases where you can't. They just don't have the money. So what are you going to do, right? I think there's nothing you can do in that case, really. If you know the client doesn't have the money and you know that suing them would be, a waste of time and effort. And that's just the lesson. Those are the cases where you learn the lesson. Do I need to take money up front? Who are these clients? Was it predictable? Wasn't it predictable? I think in some cases it was because of who the client was, maybe where they were from, different things. There are those factors, but the reality is you can't, everybody's going to get stiff sooner, somewhere along the way. And you have to just not let it eat you up, because I've had those where it aggravates me and it's not worth the aggravation.
Other thoughts or comments?
If I may, Alexander, I believe that the best way, I agree with what Joel suggested, with every word. The best way of dealing with non-paying clients is just make certain that you will not have non-paying clients at all. And I believe that if you put a lot of efforts in developing such an intake procedure within the law firms that enables noticing the most frequently occurring risks in the client relations with regards to the payment, then you can basically avoid such an uncomfortable situation. We all knew that the non-paying client, when you took this client in, you had this second thought for a moment that probably this client is not the type you would trust with your money, with your services. But you then said, that's okay, I can live with that. It's still a huge project and the pay is good. But then another problem occurred. If you know about the risks in advance, you can try to avoid or at least minimize the problems with the debt. Well, I'm really proud to say that my clients, law firms and law departments always pay my bills and pay on time, in time. And just because I'm extremely selective in having these clients.
Well, also
that's
you're
the privilege
also
I really wanted to have in my praxis. But the law firms can basically define whether or not they will have a problem of non-paying clients, or they will avoid this problem to the big extent.
Of course, Alexander, also you have another advantage. You're almost 2 meters tall.
Yeah, but he's far away.
I'm sorry, I probably didn't hear, I didn't hear you.
That's just, I was just commenting that you are almost 2 meters tall. So naturally, we're going to pay you. One other person in our conference, I'm not sure he's available, Boris Boyanov from Boyanov and Company in Bulgaria, a member of Southeast Europe Legal Group. Boris, are you available for comment?
Any comments in few minutes, because I just joined. I was in the car in a meeting and I didn't follow the conversation until now, but I'll gladly join in a few minutes.
Okay, good. Thank you.
For the next point, I'll be ready.
Okay. Well, our next point is we've discussed some questions here. Now, my next question for everybody is, what else in the law firm client relationship should our conference address? What are other questions or issues that we haven't discussed, but which you feel are important and should be discussed? What are we missing?
Norm, did you discuss the partnership to consider the relations like relations between partners?
No, we haven't. We haven't. And the way that could affect the relationship with clients, we have not discussed that. Do you have any views on that, Boris?
Well, not really, but I assume you spoke about long-standing relations forever, trust, etc. But if in those relations both sides are equal, I heard in the car that you're talking about mutual respect. But in addition to that, they're just gradually continuing and thinking about, for example, just to give you a few examples, like the big firms, they have like Clifford Chance Connect. So you enter their platform, you work with documents on their platform together with them. Then you invite clients to enter your intranet or your space just to review the invoices, to give you immediate connection. The technologies nowadays allow quite close cooperation on a daily basis. And I think it changes the perception of the relations as well. And it will lead for further changes, I'm sure.
I would probably add, and I think that, that's very valid point from the points from Boris. But I think that what's also important is that to very much extent, and we're seeing this in day-to-day life, especially during these COVID times, in many cases, lawyers are playing the role of psychological consultants. So it is not just purely legal advice. It's sometimes not business even advice. It's sometimes it's a personal advice. So I think that psychology, kind of emotion and intellect are playing an extremely important role in the connections with the clients. And I believe that at the end of the story, that's still person-to-person relations in many cases, at least. And this is an important part. Yes, the work has to be done in a very professional and high-quality manner. Yes, we have to be reasonable in price. But in case there is no personal connection, there is not personal kind of respect, there will be no work done. Unfortunately, the client will not just rely on your professional skills in many cases. So I think that it's important that lawyers are somehow able to understand what is this, how it works, what exactly is the situation, for example, in the hard times and the good times. I think one of the best options to deal with the client is actually the time when lawyer is making a mistake. Because as soon as everything goes fine, goes good, then you are able to deal with the situation in a very easy manner. But if, for example, there is need to increase the price, or there is need, for example, to make some revision in what you did before, or there is a trouble that client is blaming you for, how exactly you are dealing with these situations? How exactly you are able, in these kind of circumstances, improve the relations versus, making these relations disappear? And that's one of the significant parts of the communications with the client. So it's based on the understanding how the client thinks on one side, but on the other side, and that's not less important, probably sometimes it's even more important, it's based on the fact how you act. And these two things are not just pure, they're not purely professional sometimes. They're sometimes very emotional, very human, very kind of, psychological.
Anna, I noticed your microphone is on. Do you have something to contribute? No. Roger, you have something?
Sorry, just to add one more word, because Vladislav was very correct, and we are psychologists, we are priests, whatever. Particularly in this COVID time, it's of extreme importance to stay closer to the clients. And if we'll give them our hand, people say for sure you'll have a friend forever. So that's regarding the partnership.
Well, with respect to the partnership, if I could follow up on that, Boris, one of our law firm clients in Latin America, this is a firm with 15 partners, so they're smaller than some of the firms represented in this meeting. But when COVID started, they assigned a responsibility to each partner to make a telephone call or a Zoom meeting or something like that every 10 days with their clients. Not for business purposes necessarily, but just to see how things were going. How is the family doing? What difficulties are you having getting to work or working from home? Just sort of a very short personal type of contact, which sometimes in normal times we don't have the opportunity to do that. And that has produced some very good results for them in terms of keeping the clients engaged in the relationship. The friend for life, as you pointed out. So sometimes we have to be, as you point out, priests, magicians, even, but more than just the dispenser of technically correct legal advice. Well, I notice we've come to the end of our time, ladies and gentlemen. Sergey, before we leave, do you have any final comments you wish to add?
No final comment. I only again address to our audience, please, if some ideas will strike you regarding additional questions which you'd like to address to our speakers, you're welcome.
Yes, let's keep the conversation going by email between now and the time of the conference. Vlad, do you have any last comments?
Absolutely, absolutely. I would like to say that that was quite an enjoyable discussion and very interesting discussion. I am absolutely sure that Norm and Sergey will be able to answer any additional questions in case you may have them. For example, Sergey can answer the question how exactly he is paying the law firm that he is dealing with and how exactly he is selecting them, and Norm how exactly he is advising them how to make the situation working for them. But otherwise, otherwise, guys, I really appreciate your time and your preparation. I appreciate the audience. I appreciate the comments from the audience. I hope that the COVID time will finish soon. Hopefully, with not only Russian vaccine but also some other vaccines. Anyway, those who will be able to join us somehow in Russia, I am sure that we'll be able to offer some Russian vaccination. In case you decide, really to experiment, but otherwise we'll probably rely on Sergey and his company to create something more reasonable.
Great.
Thank you very much, guys, and I hope to see you and to see and to hear you during the next event that is scheduled for next Thursday, same time. It will be dealing with the way how lawyers present themselves, how we speak, how we convince our clients and the authorities, and how exactly we're able to be more efficient in our communication. Thank you very much and enjoy the rest of the week. Thank you, guys. Bye.
Thank you, everybody.
Thank you. Bye.
Goodbye.
Thank you, everybody.